All right. Well, hello, everyone. Thank you so much for joining us today. We're really glad to have you and on this webinar. I'm Adam Odom, like I mentioned before, a CPA and a partner at LSL CPAs. I'm really excited about this topic that we're about to dive into, and I'm looking forward to Megan sharing this knowledge with us. Maybe you've noticed that this webinar isn't about a tax or accounting issue. So why is a CPA firm hosting this? We understand the issues impacting you and your business. They cover a wide variety of areas. While we can't directly solve every single area that you face, we know the right people who can. We connect you with professionals and ideas that address what is relevant to you. And one of those professionals is Megan. Megan and I were having lunch a few months ago and got talking about what happens to social media accounts, brokerage accounts, smartphones, or whatever, when someone is incapacitated or dies. She's done quite a bit of research on this area and works in this area, and I thought our clients need to know this. They need to know everything about this and need to address this in their planning. So we asked Megan to present this to you today. Before I introduce Megan, to get started, a few housekeeping items. If you want to ask a question, just look at the chat bubble icon at the bottom of your screen and click it. A Q&A box will pop up for you to type your question in. We'll wrap this presentation up about 10 minutes before 11 o'clock for all of your questions that you may have for Megan. We'll also be sending a link to the recording of this webinar later today, so you can listen to it again and share it with others. Now I'd like to introduce Megan and get this program started. Megan Moghtaderi is an associate attorney at TLD Law. Her practice includes trust litigation, estate planning, probate, business formation, and business disputes. Growing up, Megan first piqued an interest in law when her family dealt with a hotly contested probate issue. After receiving her undergraduate degree, she went on to Chapman University Fowler School of Law, earning her JD in 2016. During law school, she worked as a judicial law extern for the Honorable Kim R. Hubbard in probate at the Orange County Superior Court. Today, Megan actively assists clients in drafting simple and complex estate plans and has developed case strategy for complex trust and estate litigation matters involving over $100 million in assets. Devoted to resolving situations amicably, Megan was instrumental in helping the Orange County Judiciary develop a mediation program for all trust, estate, probate, conservatorship, and guardianship matters. On to you, Megan.
Thanks, Adam. So I'm really excited to give this presentation today. When Adam and I were talking, I was telling him just how important it is to really protect your digital assets and all that it really entails. So I wanted to go over kind of what I think some of the key objectives are for today and what I really hope that everybody can take away. So first of all, I really want to make sure that everyone understands what are digital assets, the basics of them, and why they matter. The other thing that I want to make sure is that we also understand the advanced planning in regards to all of your assets, what is needed beyond digital assets, and why estate planning as a whole is really key. And then we will also address some of the criminal and federal regulations regarding digital accounts, as it's a different area of law that most people don't expect is going to be required as an understanding for digital assets. And finally, we'll just take away some individual practical takeaways so that you all know how to be planning well for your digital assets. So first off, what is a digital asset? The California Probate Code defines a digital asset as an electronic record in which an individual has a right or interest. And the term digital asset doesn't include an underlying asset or liability unless the asset or liability is itself an electronic record. That's a bunch of jargon, so let me explain it and break it down. Essentially, a digital asset is the information stored on a digital device. So, and it has to be the asset itself and not the overarching thing. So let's take, for instance, like an email address. You've got your Gmail account. Well, the Gmail account is not going to be your digital asset. It's going to be the records and emails that you send on your Gmail account, the Google Docs that you have, the pictures that you upload. All of those things are going to be the digital assets that you as an individual have a right to. What's important to note is that it's the information has to be owned by an individual. So it's not just the information that a business entity or an employer may have. It's the information that an individual has a right to in their own individual digital access. I want to make sure that it's very clear here that it's person to person and key in that way, because there are other rules in regards to entity ownerships. So it's the individual who has the right to use it, and it's their content that is uploaded onto a website. These are the assets and rights that somebody has to any digital property, like the electronic communications, assets that you may own in a video store. Take, for instance, like Second Life and other online gaming. Anything purchased on there is a digital asset. So there's a whole wealth of different ideas and opportunities out there. Some more examples of digital assets are things like airplane miles, social media accounts, digital files, so like images, videos, graphics, audios, presentations, stuff like that, software licenses, online stores, domain names, and then the ever-expanding mysterious world of cryptocurrencies. Honestly, the world of digital assets is continually growing and changing as technology is burgeoning. We're finding a lot more opportunities as we keep finding more applications and making more room for technology and growth. We're finding more opportunities and more liabilities for each individual to have a lot more digital assets than they would have had in other regularly held assets. So it's very important to make sure that you are thinking about your digital assets and thinking about it very inclusively, because it's a big, broad area that's growing. I mean, this is a very recent area of law, though, so a lot of people are kind of confused on how to handle it because technology is advancing beyond that of the law. That only in 2008, though, is when we started a blockchain. So we're looking at the whole world is changing as of 10 years ago. And now we have the law is trying to pick up, and we have issues with Apple and the FBI in regards to those digital assets. And the California Probate Code just adopted the revised Uniform Fiduciary Access to Digital Assets Act only in 2017. So it's a very new area and very complicated. So I'm hoping that we can take away some key points today so that it can be a little less mystifying to everyone. So what controls digital assets? There are basically three sets of controls: the EULA, terms of service, and a power of attorney. So a EULA is the end user license agreement. This says that whoever is the user of the account, your Gmail account, your Yahoo, your Facebook, your whatever, once you pass away as the user, it is the end of your license to use that account. So it just automatically terminates. Certain applications have a EULA and certain ones don't. So it depends whether or not you actually have it. It's always within the fine print that none of us ever really read, but should read, that we find out if we have a EULA on any of our accounts. That is going to be listed in the terms of service agreement. So a EULA is a part of a terms of service agreement. The terms of service agreement says whether or not your assets are going to be held indefinitely and out there for all the world to see many years after you're gone, or if there's any way to shut those accounts down, if there's a power to control it, who has access to it. It's all in that fine print. So one of the key things to take away is that you need to look at both of your fine prints to see if you have a EULA or a terms of service agreement, as those are the first controlling powers. The next thing to note is that there's a power of attorney. So a power of attorney can be just general. Generally, let's talk about what a power of attorney is so that you guys are all on the same page with me when I talk about powers of attorney with regards to digital assets. So a power of attorney is basically monitoring who gets to have control over your finances. Estate planners generally do a power of attorney for assets when somebody becomes incapacitated, that whoever is the authorized agent gets to come in, take control of the assets, and use them for the benefit of whoever signed that power of attorney. So this is a legal document that we use in conjunction with an advanced healthcare directive, a will, and a trust as a comprehensive estate plan for most individuals. What's different with regards to a power of attorney for digital assets is it's giving specific authority to go online and use whatever digital assets somebody may have. So using that cryptocurrency, going on to grandma and grandpa's bank account and making payments, doing all of the online transactions that we may otherwise think are completely allowable under a power of attorney is actually not specifically authorized without a digital assets provision. So we want to make sure that every estate plan actually has the power and authorization for using a digital assets. This can be usually within your trust or will, but you want to make sure that it's also within your power of attorney, because you want to make sure that it's very inclusive and includes the protections for all of your assets. The last thing to note is that there is a statutory authority. So this is under the California Probate Code. As I mentioned earlier, it's the Revised Uniform Fiduciary Access to Digital Assets Act, called RUFADA, so it's very long, but it gives the power for somebody to control digital assets. There's other code sections that are really important to note, one being the Stored Communications Act and the Computer Fraud and Abuse Act. So the Stored Communications Act is looking at who has the right to access any online accounts, but more within regards to criminal law standards. And the Computer Abuse and Fraud Act is definitely looking at who can be prosecuted under federal law for improperly accessing online accounts, and mainly thinking about it more as a fraudulent access in regards to trying to perpetrate and making assets be improperly used. So I'm a visual learner, so I wanted to make sure that everybody kind of had a diagram to kind of understand this. So if you look here, you see that there are a few powers that actually restrict whether or not somebody has a right to access a digital asset. So it's governed generally under, like I mentioned earlier, the terms of service restrictions. Who gets the power, who's restricted from using it, and any concerns that we may have under the terms of service or EULA. Like I also mentioned, there's the cybersecurity laws. So the cybersecurity laws are what are protecting users from being abused by somebody improperly accessing their accounts. This has been enacted post 9/11 to really make sure we're countering any terrorism for cybersecurity. And then we come to privacy laws. This is in regards to all of our amendments and rights here as citizens of the United States of our right to privacy. So who really gets to be accessing all of our private information? Now that we have digital assets, things and accounts are becoming a lot more prevalent and available online. And we want to be making sure that people are not being abused by infringing on their rights to privacy. So with digital assets, you have all of these three powers in play that are kind of hinging and balancing to see who actually has the right to access things and who doesn't, and how we can manage who may or may not have those rights. So under RUFADA, we want to make sure that it's a fiduciary has a right to access. So let me define a fiduciary. Fiduciary is really somebody who has a power to be using things. So it's like the power to access online accounts, the power to go to the bank for somebody, the power to access medical records. It's somebody who owes an obligation to another individual in a legal capacity. So they are responsible and held to a higher standard than just anybody going around informally assisting. So if you are named under a power of attorney, if you are named in a will, if you're named in a trust, and you're helping out and doing the work, you are very likely a fiduciary. The fiduciary means that you have a right and an obligation to act for the benefit of whoever is under that document. So for instance, under a power of attorney, you have the obligation to be helping somebody out who signed that power of attorney if they are lacking capacity. The same is true for a trust. If you are named as the trustee, as the fiduciary trustee, you're supposed to be using your powers to be helping out the beneficiary of that trust. So with regards to digital assets, it's governed and protected under this code section to make sure that you are properly helping out the beneficiary, the principal as the agent that you are as the fiduciary, to make sure you're protecting their interest with regards to their digital assets. The key difference here, though, is that it doesn't actually apply to the digital assets of an employer. So like I mentioned earlier, when we're wanting to make sure that it's all in regards to an individual, it doesn't apply to a business entity. So RFADA is not overseeing legal entities and who gets access to those digital assets. However, it's very important to make sure when you are using a digital assets to see who is the employer, who's the employee, if it's owned by a company or owned by an individual. So we'll want to be making sure that in using a digital asset and planning for an entity, that your entity is set up well and that your estate plan is set up well and that there's a distinction between them to be able to know who has the authority to access any digital assets. The other distinction that we want to make sure is that it needs to be somebody who's residing in California. So California law applies to California citizens in regards to digital assets. They're going to be protecting the citizens of California as regards to what users get to be using and who accesses it for digital assets. So the first right of access under RFADA is, like I mentioned before, it's the online tools. So sometimes this takes place within a EULA, but other times it can take place in another type of tool. So for instance, Facebook has a legacy contact. So if you go online to your Facebook account under a random setting that you may not even know is there, there's a legacy contact. You can select somebody who gets to decide what actually happens to your account. Or you can even select that you don't want your account to exist anymore. So upon your passing, if somebody presents a valid death certificate, your Facebook account can be shut down if you wanted it to be, or your legacy contact can control what happens to your account. This is giving somebody on Facebook, presumably someone very close to you, the power to be controlling what happens to your online presence. They can accept new friend requests, they can accept new Facebook posts on your page after you're deceased, or shut it down altogether, not permit any content to be added on there. It's a lot of rights and a lot of restrictions that you can give as a user on what you want. And that's just, for instance, of Facebook. There's also Google's inactive account manager. If you just know that you are always on Google and never not using it, because it's a very useful platform, that if you don't use it for, let's say, a month, that Google should say, yes, this person is now deceased, versus somebody who doesn't use it very often can say, oh, you know what, if I don't use it in 2 years, then I might be gone. These are different ways and different accesses that you can use to limit who has access to your online presence. This actually supersedes the terms of service because you are opting in. You as an individual are controlling what you want to have happen. So if an online service provider has a tool that you can use, it's obviously one of the best interests to go ahead and use this first level to go in and decide what you want to do with those accounts, what preferences you may have, what you want them to do, if you want it to be shut down, go inside each of those accounts and determine what you want to have happen. This also supersedes anything within an estate plan. So a lot of people think I can just do my standard estate plan and it will take care of everything. Great, it's true. But if you notice, it's actually down on the second level as an estate plan. So we always suggest that you go into each online product that you have and select a tool to be authorizing your estate plan or to be in accordance with your wishes. So again, under the second level, we do suggest that you have an estate plan that includes a POA, a power of attorney, because not every tool or every service includes an online tool. So in order to be all-inclusive and protective of your assets, we definitely suggest that you create a thorough estate plan that includes a power of attorney protecting your assets and a trust that also protects them as well, since digital assets can be growing exponentially. And then the third level is that terms of service agreement. If all else fails, it's going to fall under what you signed when you signed up. So making sure of who has the rights to access it, you want to be going through all of these levels. So if you are given the authority as an agent to have access to digital assets, as a fiduciary, you are really responsible for a lot of things. But the most important things to note is that just like with any other account, if you had access to grandma and grandpa's bank account and were writing checks, you have just as much obligations and responsibilities. So you have a duty of care, a duty of loyalty, and a duty of confidentiality. So it means if you are accessing information for grandpa and grandma, mom, dad, sibling, whatever, and you find out some information that you're like, oh my gosh, that is just outlandish. We'll get to later some crazy stories, but if you find out some information that you're like, oh my Lord, I cannot believe that grandpa really had that on his, you can't really reveal that information. You have a duty of confidentiality. So it's a big opportunity for someone to select somebody as an agent, but it's also a huge responsibility to accept that role as an agent for your digital asset. So in regards to your roles as a fiduciary, there's a lot of implications. So you want to be making sure that you are reviewing any terms of service agreements that were signed. If you've been selected as an agent, if you are signing one yourself, obviously I do recommend you review the fine print before you click on anything and sign. But I do say if you are an agent stepping in for somebody, you want to review all the documents, including a terms of service agreement. You want to see what sort of authority you have, including any applicable law, if you've got any copyright law with regards to digital assets. I mean, we're talking about in a world where you can download and stream music and people are putting up their own pieces on SoundCloud that they can get paid for. What obligations are there? Is there something that you need to know with regards to how do you collect the funds from that? How do you collect for Instagram followers if you've got somebody that's a celebrity on YouTube? How do you manage all of that? And you want to make sure that that's appropriately handled within your estate plan. And as a fiduciary, you want to be reviewing all of the online accounts and all of the powers that are given to you. But you do want to make sure that you have the full scope of your authority, what you are or are not allowed to do. So there are general powers that you could be given, and it could be very broad, but it could also be very limiting. So you really do need to look over what documents you have and what powers you are given, and if you are given the power whatsoever. A key thing that I really do want to note is a lot of people think, I'm just helping out grandpa and grandma. I can log into their online bank account. I saved it a while back and it can help them pay their bills. It's no biggie, Megan, I'm going to be fine. Unfortunately, that could be construed as impersonating a user, and that would be a violation of law. So don't do that. You want to make sure that you have the express authorization to be accessing online records. You don't want to be impersonating any user, saying that grandpa and grandma said it's okay without actually authorization being given to you. Particularly with an aging population, you want to be making sure that you're not inappropriately accessing things, as it can be a very tenuous place to be, speaking from trust litigation. So under Probate Code 880, it's a fiduciary who has a right to the property of someone who set up a trust or otherwise to access the digital assets. They want to be making sure that they are using that right and interest, that it's not held by a custodian or terms of service agreement. So the custodian would be like Google or Facebook itself, and not the underlying asset, as we talked about earlier, the digital asset. But the important thing here is Nothing under the law actually requires any custodian to share passwords, decrypt devices. So if you're wanting to get into somebody's iPhone, nothing's requiring Apple to open that iPhone for you. You have to know how to access it yourself, even though you have that power of attorney. So the scope can be quite broad, but you want to make sure that you have all the tools that you need to actually access that online record. So it is very important that you actually have all of that information, because otherwise, if you go, I need to get into the iPhone and I don't have these powers, what am I going to go do? Well, I'm going to go hire a hacker. Then you start getting into some of the Computer Abuse and Fraud Act, or some of the unauthorized access to digital assets. So having the information stored for how you access online records and digital assets is key, because you want to make sure that any agent that you had nominated actually does have the power to do what you wanted them to do in the first place, and is not going to be prosecuted for them doing what you wanted them to do, or is not going to refrain from doing what you wanted them to do because they could be prosecuted. So now we get to some of my fun examples here. The first one is a little unfortunate of a situation. I had a client who was a young mother, and she knew that she had cancer. So she wanted to set up notes for her son to receive, but using online accounts, because she knows that paper burns, you lose track of it all the time. So she went onto her email account and wrote emails that she wanted to have sent to her son's email address on certain events. So like each birthday, his college graduation, high school graduation, when he got married, those key moments that every mother would want to have for their son. She wrote those lovely, lovely notes. Unfortunately, she passed away and didn't have all of this put into an estate plan, and didn't have the access for those accounts. So those email accounts were closed. The emails that she wanted to send her son would never be sent. My client came in and was asking what we could possibly do to access it. But unfortunately, because she had never put in any powers for her digital assets into her estate plan, my client, as the fiduciary, didn't have any right to access these things and give the letters to her son, the deceased son, which is just a good horror story for everybody involved, to make sure that things that are very important in online documents that are saved, that somebody has a right to access them for the important times. That brings up another key point, like I talked about earlier. We did have a situation where somebody was trying to access a phone, and it was an iPhone, and it was locked, and nobody could access it because they didn't have the user's information. And because on that, it also had important key information with regards to financial assets, we had to open a probate. So you had to go through the probate court, file all the documents, go through an entire long probate proceeding just to be able to access somebody's phone. So it can be a drawn out process that we never recommend. Another one that I've seen on occasion is royalties. So if you have any copyrights, if you have those YouTube accounts, you have your Instagram page, any followers, that you're a crazy celebrity and an influencer, all of these things you want to make sure are put into your trust or put into some sort of way of somebody accessing it. I always recommend a trust, but for different reasons it may not be needed. That would be dependent on an individual. But you want to make sure that those things are done. We've had situations where somebody did not do that, and instead we've had to open a probate and go through a long proceeding to get the rights to access ongoing royalties. So like, for instance, Prince's music, was it included in an estate plan? For instances like that, you definitely want to make sure that somebody is protecting all of their rights. And that can only be done for inclusive estate plans that include all of your digital assets. The last one is kind of my favorite, is seeing all the salacious stuff that Grandpa was into. We've definitely had a few instances where You've been granted the authority under an estate plan to open up all of those documents, and you just see everything that somebody is definitely reviewing and has an interest in. But you want to be making sure that you actually have the complete authority and know what grandpa would have wanted you to do. Probably shut down those accounts. Having all of that information in an estate plan is really key to making sure that you are thoroughly protecting what you want to have happen, even beyond what you have your fiduciary do. You want to make sure that you are clearly and completely delineating what you want to have happen to your accounts. Another few that I haven't really put on the slides, but that I've experienced was, we've had a few brokerage accounts that people used online and did their online e-trading and all of that, but they didn't list it in any of their estate plans or online documents. So nobody knew that these things existed till many years later. And since then, we've had to open up probates because there was an online account that somebody did not use their digital assets to protect. And so somebody has to get authorization to use the digital assets. Somebody has to get authorization to collect all those accounts, collect all the money, and then distribute it. And it's a very long process that can be avoided if somebody knows how to create a power of attorney and agency for somebody to appropriately access their assets once they pass away or are incapacitated. This has been a growing concern nationwide and actually worldwide. In Canada, they recently had somebody pass away that had $190 million that didn't have any access to digital assets. So in Canada, they're trying to figure out right now, what happens? Where do we go from here? Because it's $190 million. So you want to be making sure that all of your digital assets are appropriately protected and included in your estate plan. So this kind of brings us to some of the new and changing laws. I wanted to throw in a little bit with regards to concerns that some businesses might have, because it's with regards to your digital assets, individuals have their own concerns, but businesses have their own as well. So under the California Consumer Privacy Act, it's going to be requirements set for use of private information for a for-profit entity. If you're collecting information of individuals, so whoever comes onto your website and gives you some of their information, name, address, serial number, whatever, you're going to be responsible for using that information. So you want to be careful how you collect that personal information, and you want to be making sure that it's following the guidelines. So under the California law, it's applying to your for-profit business. If you have more than $25 million, if you have personal information of more than 50,000 consumers, households, or devices, so they access your website on 3 different devices, that counts as 3 uses right there, and earns more than half of its annual revenue for the sale of consumers' personal information. So if you're using that personal information for anything, you want to be very careful. This personal information is information that identifies, relates to, is being associated with, or linked with a particular individual or household. So it's a very broad definition. It doesn't mean that I can specifically identify that it is, in fact, Adam Odom, but I think, it's probably from the Odom household. Then it's pretty important and applies. This law is going to be taking place in January 1st, 2020, so it's going to be upcoming. But it's the first of its kind in the United States. It kind of differs from other international privacy requirements and is a little bit broader, so it's something to definitely keep an eye on. One of the things that you can do as a business owner is to definitely consider having an opt-out link on your internet homepage. It allows for the sale of your information. You can say that, hey, I do this, and let consumers then opt out of that. In addition, you want to make sure that you update your privacy policy for all of your digital accounts for somebody who comes online to your website page, to make sure that it's very clear to any user if they read your terms of service and privacy policies, what exactly you're doing, and that it does protect you a little bit more. So that brings us back to the criminal law and data privacy. So the Computer Abuse and Fraud Act provides penalties for accessing any protected computer without authorization. And if it's beyond the scope of your authorized position, if you access it, it protects it. So there's confidential digital records, and if you are accessing them at any point, you could be in violation of federal law. And it's not something to be taken lightly, as the FBI is pursuing it more and more heavily. For instance, one of the biggest issues was with regards to FBI and Apple. In 2016, there was the whole issue with regards to access of a individual's iPhone, and they wanted to access on there to determine if there was any federal crime that might be committed. Well, Apple refused to grant access to the phone because they, as a custodian, prior to the enactment of the California Probate Code, determined that they did not have the authority or obligation as a custodian to provide access to those accounts. This has been upheld and is actually a source of contention for a lot of people, but it does mean that if the criminal system upheld FBI not being granted access to the iPhone, how much more is an individual who's trying to access somebody's digital asset going to be implicated if they do so? So backing up a little bit, let's talk more about what happens to your digital assets upon an incapacity. Incapacity is really simply stated as someone who physically or mentally is incapable of taking care of themselves in some way. So unless a digital asset specifically mentions a power of attorney or an estate planning document or provides access for an agent within the tool itself, there's not really going to be any power that's given to an agent to access those digital assets. If there's going to be extreme necessity to access those digital assets, if there's an online brokerage account or grandma was really involved in cryptocurrency, you may need to get into a conservatorship. And a conservatorship is another very long proceeding that we definitely don't recommend. So we always recommend that somebody who has capacity plan while they still have capacity. And we say the best time to plan is when you're young, because your question of capacity is not even there. We all believe that you definitely know what you're doing when you are a young individual, despite what people may say. So I know that we're backing up a little bit to what some business owners might have concerns with, but with regards to accounting software, there's a few things that you may really want to know. It really is just going to depend on your terms of service use. Who purchased the license to use the software? Is it in the name of the business? Is it in the name of an individual? Who are the authorized users? It's a very complicated area, like any digital asset. But for instance, I wanted to make sure that Adam knew, as an accountant, what happens to your online accounting software. But you don't know. You need to make sure you look over terms of service and see who has the right to use it. So for like QuickBooks, is it purchased by your entity, or is it one individual who purchased it and then it's being used by the entity and all the users are just under one umbrella? You want to be making sure that it's getting held separately between your business interests and your personal estate, very separate and distinct, so you know who is the authorized users for these accounts in case something happens. Because if something happens to an authorized user, or the only authorized user, does it shut down? Does QuickBooks or any other online service say you can't use it anymore? Is it just an online service? Did you purchase the underlying software? Is it just a license? These are very important considerations, and you need to make sure, like with any other digital asset, that you are thoroughly reading all the terms of service use and every legal document that's presented to you, because it can prevent some access that is really key to make sure you have. So how do you plan for your digital assets? 1, prepare the list of digital assets for your loved ones. if you don't know what all is out there, you can't actually take care of it. So start thinking about all of your digital assets. Take some time, sit down and start writing that list. Write a list of everything you have, because it's going to continue to grow as time goes on and we get more assets available to each user, but you want to start with what you have. 2, you're going to want to use the tools in those assets. So like go on to Facebook or your other online accounts and use whatever tools are available. I'm going to be sending out later a list of different types of tools that are available and what it controls it, so you actually have a little bit more information. That's too in-depth to go through during this little webinar, but I wanted to make sure everybody had a little bit of takeaways that they can hold on to. 3, password managers. Like I said earlier, the custodian has no obligation to give you the password to those accounts. So if you are creating a list of all of your accounts, there's online softwares that you can use and that gives particular individuals access to all of your accounts, and it includes all of the password information. I'm not going to recommend any particular one since all of them could be susceptible to any type of hacking, but none of them have been as of yet. But you can also do it in an old school way, having a running list and a piece of paper with all of your information and storing that in a very safe place. The last one is make sure you have a legal plan in place. And that's not just, I have a plan in place in a theory, that's enacting your plan. So like a fire plan, you make sure your family knows the drill, you run through it. Here's what we do in case of a fire, and you actually go through the motions. Go through the motions with an estate plan. Make sure you actually have one in place. Execute it. Make sure it's signed. Make sure it's stored in a safe place. And make sure your attorney knows what your digital assets are, so that if something happens to you and you didn't set something up appropriately, somebody knows out there what's going on. Okay, so that's if you were planning. But now if you're trying to access it, how do you locate your digital assets for somebody that passed away? One, you're going to want to make sure you look at any bank statements for any reoccurring charges or deposits. So if you're getting any income or revenue coming in from an online source, check the bank statements. It should tell you very clearly if something is coming in so you can further investigate. 2, you're going to want to review any names, email accounts, and social media sites to see if they had an online Twitter account and you didn't think Grandpa was tweeting this entire time, but turns out he was an avid user of Twitter and it has very great followers. 3, just ask other people. You may think you know somebody entirely, but everybody else has a different perspective. So ask other friends, family members, what sorts of online presence somebody had. See if they had an online club, anything, if they like video games, stuff like that. And like reviewing bank statements, review the mail. You can see what comes in the mail if somebody was interested in online video gaming, if they're starting to get advertisements for new video games. Things of that nature. The mail will tell you a lot. So review that and see what comes in, and you may be able to do some further research and reconnaissance and become a little private eye. So hopefully they have planned ahead like you and have used a schedule to prepare what all of their digital assets are. In my office, we call it a Schedule D for a schedule of digital assets. And that has the usernames, and then we have a place that we know that the passwords are held, such as a password manager. So like I said, I'm also going to be sending you a list of digital assets checklist to make sure that you've accurately protected. So after the webinar, I think that's going to be going out for everybody. I think that's it.
All right. Thank you so much, Megan. That was really good. I think the biggest thing that I got a ton out of it, but biggest thing is to be proactive instead of reactive to all of this. So the best person to contact to be proactive out of this is Megan. So it was great. Just a reminder to everyone, if you have any questions, it's in the Q&A section at the bottom of your screen. We did have a few questions, so if you're available, Megan, we'll go through those. So one of the questions was, how do I know if my estate plan protects my digital assets?
That's a great question. The first thing is to read your estate plan. So hopefully you have one, which would be great. and read through it, see if it has any powers with regards to digital assets. A trust can be quite big and lengthy and kind of confusing to maybe a layperson to understand. So go to an attorney, ask them to review your documents to see if anything needs to be freshened up, if it's in there. And a good rule of thumb is if it's before 2017, it probably doesn't have any digital assets protections in there, because as of 2017 is when the new law for access of digital assets came into place.
Great, thank you. Another question was, why do I need both a power of attorney and a trust?
Great question. So a power of attorney is, I call it your hit by a bus document. So if something happens to you and you're incapacitated but still alive, who's going to be handling all of your finances and all of your digital assets? That's your power of attorney. Compared to your trust, it does handle all of your assets while you are alive, but it's only stuff that is held by your trust. And it goes on beyond your death. So if you want to make sure that somebody has the right to control your digital assets after you're gone, then you want to make sure that you have a trust in place.
Right. And then the last question on here so far is, if I have all my social media accounts in my trust, but then open another account, like an Instagram account or whatever, and something happens to me, will that hold any weight in the powers that be or seeing my attention, or and would it allow relatives to access, or will they need to go to probate for that?
Okay.
Any new social media accounts?
Yeah, so that's a very good question and involves more of a complicated answer. So let me kind of explain in background. So if you are setting up a full estate plan with a power of attorney, advanced healthcare directive, will, and a trust, normally what estate planners will do is they'll create a pour over will that says, I intend for everything after I create my trust to go into my trust if I acquire assets later. Then on the trust, it says all of my assets that I currently know. So under the probate code, under section 850, there's also a case law called the Estate of Hegstad. It says that if you later acquire assets that you intended to be in your trust, and provide evidence that you intended it to be in your trust, but it somehow was not there, that you can bring a petition in probate, not necessarily a probate petition, which is kind of complicated to explain, but you can bring this petition to have it put into your trust and be managed. It's a shorter process, but it still involves going to court. So we obviously recommend that anytime you get new assets, that you definitely see your estate planning attorney to make sure that they're included or that they're properly protected. Each asset has their own unique quirks, so it's definitely important to talk to an attorney that understands all of the complicated nature of each of them.
Right. That was the last question. So if you could go to the next slide.
Okay.
So just for everyone to know, we do have an upcoming webinar on November 7th, where it will go through 5 areas where our businesses are overspending and other expenses. So make sure you'll be receiving emails on how to sign up for that. So make sure you sign up for that. Okay, everyone. And then thank you, Megan, for your time and for sharing this. This is great information that I think a lot of people don't even think about when they're going through their trust and what happens to that. So I appreciate that. And thank you everyone for attending this webinar, and we look forward to seeing you in November. All right. Thank you.